water rights permitting update. You can see a continuation from what we were just discussing. And Amy, it's all you.
Somebody stole the clicker. There we go. All right. Thank you much, everybody. It's great to have such a large turnout and crammed on in here. That's excellent. Just a little bit of background on me. Like I said, I'm a hydrogeologist. I've been with RH2 for about 7 years. I was with the Department of Ecology Water Resources Program for 8 years before that, doing I was hydrogeologist permit writer in the Water Resources Program. So working on water right decisions. And I was a section manager down there for a few years. And then I'm also a certified water rights examiner. So talk today, I'm going to go over the application backlog a little bit. This was something that got a lot of press a few years ago. I took a look at it, thought it'd be interesting for folks to see how many new applications, change applications are pending in the state. We're going to talk a lot about change applications, the types of changes that are being performed, mainly in Whatcom County, because I think this is Whatcom County specific. The goals of those water right holders, you know, what they're trying to accomplish by going through the water right application, change application process. We're going to talk about the Foster decision, which Chuck touched on a little bit. And then we'll talk about other sorts of changes like drilling a replacement well. You know, what do you need to do from a water rights perspective before you hire Bill to come out and drill your well? You know, I want to make sure that you don't trip over any of those things accidentally just without knowing about them. So I'll tell you about a few of those. And then we'll actually talk about some new applications that have been processed in Whatcom County, both uninterruptible, a new irrigation water right that's uninterruptible, processed in the past couple of years, and then a batch of new applications that were interruptible by in-stream flows and what that means, interruptible versus uninterruptible. So the water right application backlog, this is, this is from 2010 through 2016, the end of 2016. The new applications are in blue. The change applications are in kind of the orangish red color. There were in 2010 about 5,800 new applications pending. This is statewide water right applications. At the end of 2016, that number's down to about 4,800 applications pending new. So at this rate, the new applications are shrinking by 162 applications per year. It'll take 30 years before that backlog is worked through. So ecology is making progress, but it's going to take a long time before that application backlog is reduced to zero. The change applications, they were just over 1,000. Now they're down underneath 1,000 statewide. They're shrinking by 64 applications per year, so 14 years to reach zero. I think there's a couple reasons why the backlog's shrinking. One, you know, ecology's processing applications, both new and change. There are more pathways for getting applications processed now. Conservancy boards are a good way for processing change applications. Cost reimbursement program, you can process both change and new applications. And I also think that water right applicants or potential applicants are also, the messaging is getting out there that in some areas, you know, filing a new application isn't going to get you anything. And so there's some education on that side, and people just aren't filing new applications, excuse me, like they may be used to. And so that's working at the supply of those new applications, you know, cutting down on the amount of new applications submitted to ecology. So Whatcom County's slice of the pie on this. End of 2016, there were 550 pending new water right applications and about 64 or so change applications. So change applications, the types of change or irrigation change applications being processed in Whatcom County. This is, we've been doing a lot of work up here. We've seen a lot of folks, so these are the primary, I guess, changes that we've seen. Place of use, so somebody will have a water right that includes maybe a portion of their particular farm or their particular area, and they want to change the place of use to include their entire farm. So that's, you know, place of use changes. Spreading to additional acres. This is very common with the berry growers, so you'll see people trying to spread to additional acres so they can have more berries being grown. Point of withdrawal changes, changing where your well is located or getting off of surface water onto groundwater. Those have been very popular. And also irrigation to industrial. So the typical goals, as I see it from the applicants, you know, when we talk to them, work with them, is more operational flexibility. So if you have a situation where you have 4 water rights and they are covering your farm, each of those water rights might be associated with a specific well, might be associated, have its specific pumping rate, specific annual volume, specific number of acres, specific place of use. So all these changes, if you change the place of use on all those water rights, if you include all the wells on those water rights and all the points of withdrawal, then you can basically have an integrated system where you can say, okay, I can pump out of all 4 of these wells to serve this entire, this entire farm. You don't have to be water right by water right, well by well specific. So I think that gives the operators the flexibility to say, boy, well 1's not really pumping that good. Let's pump out of well 2 a little bit more, or well 1's gone bad. We need to replace the pump. Good thing, we're not limited to just using well 1 for our water right. We can take it from these other 3 wells as, in addition. So the operational flexibility is a big thing. The spreading water to additional acres, this is often done to make sure that all of their acres are covered by a water right. So irrigators might have 4 water rights on their farm, but they have these properties in between that aren't covered. Maybe they're currently being irrigated and they want to spread their water out. So they can't irrigate as much on each particular acre, but they can have all of their acres covered, and then they don't run that risk of ecology coming out and saying, hey, this 40 acres of berries, you do not have a water right here. You have to shut down. As berry growers know, berries don't like that when they don't get water during July, August, September. So it's preventing a situation where you might have a big capital loss based on regulatory action, potentially. Getting off of surface water, this is another one that is coming up a lot, I think. And you guys probably know more about this than me. I don't know if it's the FDA or whatever, but they want clean water being applied to the plants so that you don't have a situation where contaminants potentially get from being applied as irrigation water onto the crop and then consumed by individuals and causing people to get sick or potentially sick. So we're seeing a lot of folks that were trying to get off of surface water sources and onto groundwater to eliminate that potential the pathway and the potential issues with that surface water sometimes has. And in doing that, we're also seeing, in this area in particular, vertical wells have limited production in certain areas. They might get 100 gallons per minute, like Chuck and Bill were saying. We're seeing a lot of folks now start to consider these horizontal wells, which Bill spoke about briefly. They're basically a horizontal collector that allows you to get much better production because you can tap a much larger area of the aquifer than you can with a vertical well. So instead of having 4 vertical wells, you might be able to have 1 horizontal well with 1 pump chamber, and you're just dealing with 1 pump. You can get the same production out of it. And a lot of times the surface water rights were for higher pumping rates, maybe 500 gallons a minute, whereas that might take 4 vertical wells to get. And so if you could put in 1 horizontal well and get that 500 gallons a minute out of that one source, it's just less infrastructure, less pumps to deal with, potentially breaking and all that sort of stuff. So we're seeing those horizontal wells coming into, they're kind of coming into their own right now. And the horizontal wells, they can have, those horizontal collector pipes can be 500 feet long. We've seen them almost up to a 1/4 mile long. So they're covering a big swath of the aquifer when they're put in place. And then the irrigation to industrial changes. The groundwater exemption, this is pre-Hearst, allowed for 5,000 gallons per day for industrial use. So a lot of folks, they were irrigating. They said, hey, I'm gonna open a packaging plant or a packing plant here. They started off with a permit exempt well for industrial use. They were using it for processing of their berries, for instance. But over time, that facility's gotten bigger and the water use has increased to the point where they're exceeding the 5,000 gallon per day limit. And so some people will change an irrigation right over to industrial to cover that additional processing plant water during the irrigation season. So that's another type of change that we've seen up in here in Whatcom County recently that people are doing. And so that kind of covers those type of changes. The Foster decision, Chuck had mentioned this briefly. I think this is going to have a large impact on changes as we move forward, specifically point of withdrawal changes. So the idea that, hey, I'm going to get off this source, I'm going to move a well, do that sort of stuff. These next slides here are I hope to inform you on that, address some of these issues that the Foster decision has brought up. And I'll give you my prediction on what this is going to mean from a water rights perspective. So the Foster decision said new impacts on closed or minimum in-stream flow regulated surface water bodies that are not meeting those flows is not allowed. So in the Foster decision, it was for a new water right, and in conjunction with some changes. But basically what it means is if you have a closed stream, the change that you're doing to your water right can't have a different impact on that closed stream. And if you look in Whatcom County, most of the streams in Whatcom County are closed. Bertrand, Fish Trap, Johnson, Sumas, there's a whole laundry list of the others. They're all in WAC 173-501. You can get a complete list of the closed water bodies. Even if they're not closed, like the Nooksack River has minimum stream flows that are not met throughout the year at different times. So any impact or any new impacts to those water bodies because of the change would cause that change to not be allowed. And for mitigation of those changes, ecology was kind of going down a path where they would consider out-of-kind mitigation, out-of-time mitigation, and out-of-place mitigation, meaning that so in-kind is water for water. So this decision said, okay, you have to have in-kind mitigation. So if you are impacting this stream by 5 gallons per minute, you have to add 5 gallons per minute of water to that stream. Out-of-kind mitigation that were being pursued, but now cannot be pursued, were things like, hey, what if we replace this culvert and allow 5 more miles of fish habitat in this stream upstream of this, what used to be a fish belonging culvert, or planting the riparian zone to add shading to the stream, things that weren't water for water, but like Fish and Wildlife and others would say, hey, that's good for fish. We understand that's good for fish, so we'll accept that trade-off. Those things are no longer allowed. The in-time requirement is if you wanted a municipal water right that was year-round, you cannot mitigate with an irrigation, acquiring an irrigation water right and retiring it, because that irrigation water right is just during the summer. Municipal water right would be year-round, so that's an example of not in time or out of time. So if you're having an impact in the summer, you need to mitigate in the summer. And then the in-place mitigation is, it doesn't matter if you have a water right that you could benefit a stream that everybody thinks, hey, that's better salmon habitat, we want to put water there. If you're impacting Fish Trap Creek, for instance, you can't acquire and retire an irrigation water right on Bertrand Creek and call it good. You need to mitigate for where that impact is actually occurring. So, so the Foster decision has made certain types of changes problematic. And so I'm going to go through the laundry list here of the types of changes and why they are problematic, just to try to better explain it. So this, the surface water use, you turn the pump on, the impact happens right then. You turn the pump off, the impact goes away immediately. So an example of a surface water impact is, you turn the pump on, boom, it goes up. You have your full impact to the stream. You turn it off, it goes down. This could be day-to-day basis. This could be throughout the irrigation season. So if you want to change from surface water to groundwater, like used to be encouraged by ecology, Fish and Wildlife loves getting off surface water. But now you have a problem where the groundwater impacts, when you turn that well on, depending on how far it is away from the stream, the impact is not immediate to the stream. There's a delay, a lag before, as that impact increases, because it takes a while for the cone of depression to propagate through the aquifer material. And then once you shut that well off, there still is this, this lag effect where the impact is still being felt by the creek outside of that season of use when the surface water impacts would have impacted the creek. So under the Foster decision, this area out here is problematic because that creek, if it's closed year-round, it never felt the impacts in October, November, when you were pumping from surface water. But now that you're pumping from groundwater, you have these lag impacts. And so these type of changes, we've been told, are not going to be able to be allowed going forward. So if you're on surface water, you're pretty much going to be stuck on surface water, or a well that's immediately adjacent to that surface water. So that basically the impacts on surface water are the same through the change process. The second type of change that is problematic is a new well that's located upstream of the original point of withdrawal, or the original well. So in this instance, we have the original wells down here. This is a we'll say closed stream, closed year round. Groundwater flow directions coming in from the north, feeding that stream. So if you wanted to move that a new well or proposed well up to this location, you are going to have a greater impact on this reach of this closed stream. Again, your impacts are changing. They're getting worse for that particular segment of the stream. So that type of change would not be allowed now under the Foster decision. Seasonal to year-round uses. This is one where you have an irrigation right. You know, you're pumping from your well. Here's kind of what your impact looks like. Instead of growing berries, now you want to grow houses on the property. So you're going to switch to a domestic year-round type use. It's not going to be allowed, even though the magnitude of the impact on the stream is much less. You know, you don't have these peak impacts in the summertime, which most people I think would say, wow, that's great. But you have these new impacts on the shoulder seasons, we'll call them, you know, the January, February, March, April, October, November, December period, where historically the irrigation right did not have that impact. So you're not going to be able to do seasonal to year-round changes. You can do, like we talked about, going irrigation to industrial. If you keep the season of use the same, you can do that. But you can't say, I'm going to go from irrigation season to now a year-round use, because there's going to be greater impact on those closed streams. If that's your particular fact pattern. So moving a well closer to a stream. In this slide, the blue well is basically your impacts for your existing well. If you move the well closer to the stream, you're going to increase your impacts, so it can propagate to that stream quicker during the summertime. So you're going to have a greater impact during the summer. That's going to be where your problem lies in this sort of change. So you're going to say, well, great, I'll move my well farther away from the stream. Well, in this particular instance, now you're going to have these lag effects. It's the surface water to groundwater change. Similar story, where now you're having an issue. You know, things are better during the irrigation season, but you're having a new impact out here, you know, beyond the irrigation season due to those, just the delay and the lag because of the groundwater source.
And how would this play out if a basin is only closed season? For example, only during the summer months.
Yep. So a seasonal closure, so these impacts are just during that season when it's closed. If they have in-stream flows, it's any time that the minimum in-stream flow, that the actual flow is less than the minimum in-stream flow set by rule. So it could be, you know, spread like on the Nooksack River, it could be pretty much any day throughout the year. Some days they're met. If the flow's being met, it's no problem. It's all those days when it's not met, which are scattered and sporadic throughout the year, that you have to then have a problem. You either have to be able to mitigate or not have an issue. If the stream was just closed during the irrigation season, let's say here, this would not be a problem. You could still do these kind of changes because you're having, you know, different impacts, but you're not, if it's not closed, then you're not limited by that. But like I said, most streams in Whatcom County are closed year round. So it's problematic. So going through all this is my prediction, just me personally. Water right holders, you know, if you look at all those options, it's like, well, geez, we can't go farther away from the stream. We can't get closer to the stream. We can't go upstream. It's very limited on a points withdrawal change now in this under this legal decision. So I think that water right holders ultimately are going to switch to just piping from the existing sources. That is the answer. They can lay pipes, you know, it's kind of more in the irrigator's control. They don't have to worry about going through that change process for that particular aspect of it. So I think that people are going to start, you know, they'll have their existing wells and they will start piping that water to those fields that they want it on, as opposed to trying to change and add a new well at that existing field. So that's my look into the crystal ball on what the Foster decision is going to have impact wise for irrigators. Yeah, Chuck.
Step out for a second. Maybe you touched upon this. Did you mention that they have the ability to put wells in, they're still within the advertised area?
Well, we'll hit on that coming up here. So, so other water activities. Look at that. Boom. Next thing up. So, showing compliance with 9044-100 sub 3. So this, if you are considering putting in an additional or replacement well, be aware of this. The statute and Ecology has a form this is a way that you can add that well to your existing water rights without having to go through the water right change application process. So anytime you can avoid going through the change application process, it's probably preferred, as long as you can get to the point where you get what you want in the end. And so the key with this, and this is like Bill was saying, make sure you know where you're drilling that well before you call Bill out and point to that spot on the ground. You want to make sure you're on the right, you're on the right side of an administrative boundary, because you can add a replacement or additional well to a groundwater certificate or a permit by going back to the original public notice that was in the newspaper. And if you look in there, it'll have a legal description for where your well is located. So in there, it might say the northwest quarter of the northwest quarter of section 14. You can, through the showing of compliance, you can add a well in that published legal description under your water right. You fill that form out, you make sure your well's not closer to anybody it could impair, your well's constructed properly. There's a number of different things you got to kind of check off on the showing of compliance. You staple your well log to the back of it and you send it in. Sometimes it's a quarter section, sometimes it's a section within a lot, within a subdivision. Each public notice is different, but always make sure, if you're considering drilling a well, make sure you know what that, what it says in that legal description or in that public notice. And then when you're out in the field, looking for your perfect spot, make sure you're not 5 feet on the wrong side of some, administrative boundary that you didn't realize ran through your field. I've seen that working for ecology, where somebody just, they came out, oh, this is a good spot to drill, and they're very close to their existing well, but they just, they went across the boundary, and now they can't do that, and they have to go through the whole change application process. So you can save yourself some time, money, and headache and hassle if you can locate an additional or replacement well within that same published legal description. And ecology has the entire water right record on file, so you can contact ecology, and they will be able to provide you with that original public notice that has, that will tell you where your wells are originally located and where you can locate a replacement well. So there, you can publish them in those areas. Yeah. So this is, and it just goes through. Ecology does not review anything. They just get that document. It goes in your water right file. So another thing that we're seeing, and this is I think really, really important for anybody that has a water right out there, the administrative confirmation of a division of water right. So this is the splitting of a water right amongst property owners. So back in the 50s, when the original water right that you're using on your property might have been issued, it might have included 120 acre place of use. So the place of use of the water right will be identified on the face of it. Ecology is on their Water Resources Explorer. They actually show that, the little polygons or the little places of use of the water rights. So it'll show it on there. If you now do not own that entire 120 acre place of use, conceivably, if it's a certificate or a claim, you jointly own that water right with those other people that own the other areas within the place of use. So if you want to come in and go through a water right change application process, ecology is going to say, wow, this is great. You own, let's say, 40 acres out of the 120. You'll go talk to your other neighbors that own the other, the other 2 40 acre sections or areas. Get them to either sign off on your change application or go through this administrative confirmation of division of water right and decide how that water right is divided amongst those various property owners. Ecology is not in the business of saying, hey, this water right's good for this person, not for that person. They say, hey, you guys figure it out. So you got to go talk with your neighbors. You got to figure it out. But they will not let you go through a change application process until there is certainty on the ownership of that water right. So even if you have the point of withdrawal or the point of diversion on your property, if the place of use includes other properties, you got to get those other people to either say, no, we don't have an interest in that water right, or each person gets an acre or whatever it might be. You need to split it up. And ecology will just look to you guys to tell them, hey, this is a water right for 40 acres of irrigation. I got 35, Bob's got 1, and these people got 4 or something, break it out like that. And then once you do that, you own that water right outright. And then you can do a change application on it. You are the sole owner of it. You don't have to then go and involve those other people that used to be within the place of use. And so if you do that now, it can just save you a lot of time later. Before you want to go through the change application process, then you got to go talk to them at that point. So it's good to have that, just clear ownership break between you and your neighbors that might be in the same place of use. So I'd highly recommend doing that if you do have a kind of a joint ownership amongst water right. So new water rights. So this is something that not necessarily groundwater, but I thought it'd be interesting because it hasn't happened very much up in Whatcom County, but it has happened over the past couple of years. So there have been both interruptible and uninterruptible surface water rights issued in Whatcom County. So under WAC 173-501, which is the same one that'll tell you all the streams that are closed, they define the stream management units in Whatcom County. And the lowest Nooksack River stream management unit is the Nooksack River at Ferndale. And that unit is defined as running from the influence of mean annual high tide at low in-stream flow levels to the confluence with and including Smith Creek, which is way up by Nugent's Corner. So everybody here knows where the influence of mean annual high tide at low in-stream flow levels is, right? Yeah, no, nobody does really. So Ecology actually, through the processing of a new water right application, determined that on the Nooksack River, that downstream point of the lowest stream management unit is approximately where the Lummi Red River splits off. So where the distributary naturally would have occurred historically. And so because of that, anything below that point on the Nooksack River is technically open. It is not regulated by the Nooksack River by WAC 173-501 because it is outside of the regulated reaches. So in 2014, there was an irrigation right that was issued for Dick Bedlington Farms, and their points of diversion were located downstream. So this is the Lummi River or Red River right here. So that's basically the point of high tide at low in-stream flow level. So their points of diversion were located farther downstream on the Nooksack River, and Ecology was able to actually issue a new surface water right for the irrigation of 120 acres down in that area in 2014, and it went through. It's a permit now. So that was one of the first new applications issued in Whatcom County that was uninterruptible in a long time. So if you don't happen to be down at the mouth of the Nooksack River, then there are other options, such as interruptible water rights. So interruptible water rights mean that when the flow of the Nooksack River, or the actual flow of the Nooksack River gets below whatever the minimum in-stream flow is for that particular day, you cannot take water. So basically the river has a senior water right to your water right. And in 2015, Ecology initiated a coordinated cost reimbursement process for 9 water right applications that requested to take water off of the Nooksack River itself. Part of these were compliance enforcement issues. Others were just applications that have been pending on the river. All of the applications were in the Nooksack River at Ferndale Reach, so that lowest reach up above so the regulated reach. The Nooksack River gauge at Ferndale is the gauge that is controlling. Most of the water rights were for growing pasture grass and corn for dairy operations down in the floodplain, because those crops and those particular operations, they can handle going without water. With a pasture crop for cows, yeah, if you don't irrigate, you might get less cuttings, but your crop is not going to completely die. These were not raspberry growers, blueberry growers, that sort of thing. There was one potato grower. They're trying to weigh the risks of a crop like that with the interruptibility uncertainty of this type of a water right. So the interruption might lead to less crop yield, but in these cases, not crop failure. So they're subject to the flows. And the Nooksack River at Ferndale, this is a chart that shows the likelihood of being interrupted on any particular day. So the red bracket here is, we'll say, a typical irrigation season, May 1st to October 1st. In early season, and then going up this side is the percent chance that the flows will not be met on any particular day. So early in the season, you have about a 20% chance on any given day that the flows will not be met. As the irrigation season progresses, you get to about the middle of July, you got a 50-50 chance on any particular day that you might have water or might be able to take water or not take water. By the end of the irrigation season, you're getting up in the 70% chance that you will not be able to take water. So interruptible rights, when combined with storage, might be something that you can deal with risk-wise for your particular crop. Depends on the crops you're growing, you know, how desperately you need that water throughout the year or throughout the irrigation season, your ability to deal with day-to-day management. You know, these water rights typically come with a requirement that every time you're going to turn that pump on, you need to check the minimum in-stream flows, check them against the actual flow, make sure, you know, that the actual flow is higher before you turn on. Once the actual flow dips below the minimum in-stream flow, you got to shut off right away. So this was a batch of 9 applications that were issued. There was lots of controversy over whether these should be issued or not be issued. There are a lot of folks that are watching to see if these folks that got the 9 interruptible water rights, are they playing by the rules? If they play by the rules, then maybe this is a pathway that more people could get water rights issued in the future. If they're not playing by the rules, then it's likely ecology might just say, hey, no, you know, we're not seeing enough compliance enforcement, or we're not seeing enough compliance with these permit provisions. It's too much work for us to try to manage this on a minute-by-minute basis, basically throughout the irrigation season, and we're not going to do it. So it's tough to manage. It's up to the irrigators to make sure that they don't, you know, that they play by the rules. Because if you don't, then interruptible water rights, which are in some instances the best water right you can get in certain parts of the county, might not be available to you. Yep. So each of these water rights had, they have a reporting and reporting. You basically you have to monitor the flow. You have to write down the flows when you turn your pump on each day that's pumped on. You have to turn that in at the end of the year. Ecology, I believe, did spot checking where they, I don't know if they floated the river to look for things to see if the pumps were on. They can do site inspections, go out just unannounced and see, is the pump operating when they know the flows aren't being met. I will so Casey Cycler's with Ecology's Bellingham field office and does compliance enforcement, and I'll let her answer that.
So we did regular drive-by inspections as well as.
Casey, how do you determine whether a field is drip irrigation?
So none of these were drip irrigation because they were corn and hay. So those are big guns, you know, very simple irrigation. Drip irrigation was very simple. Some other options.
Yeah, but so far nobody with berries has been, or you know, raspberries, blueberries, somebody that would be doing drip irrigation. Nobody's been interested in this because of the high percentage chance that you're not going to have it. You know, it's not a firm source of water. It's something you're going to have sporadically at best. So it's just those crops that can manage that drought stress that have been utilized. Yeah.
Where does the mandate of flow meters come into this? You guys monitor.
Where does the mandate come from, or?
Like the flow meters come in, when you guys come out, you can check flows. There's actually proper data there.
Yep. So the Surface Water Code 9003, I think, says every surface water right shall have a flow meter on. Through the water right application process, in the provisions section, the flow meters are required, and also the monitoring and the reporting is required. So it's through the permitting process, add those provisions on there of the water right. And so that's where does that answer your question, or?
You guys, they're actually progressively checking that, or?
Yeah. So in the late 90s, the legislature decided to make these laws about including reported water use. So we see with the largest users here in Washington County and other counties around the state, they were required to get including their water use. And then any of the water rights that get touched in terms of issuing any water right or any of the changes. Generally, unless it's a very small use. Those are provisions to record. It's all meter record their water use and the frequency of reporting
Yeah, there's also required, the meter has to stay good. You can't just put one meter on, it dies in 5 years and then you're off the hook. It's something that you're responsible for maintaining it, making sure that it's, within reasonable parameters for being accurate. And like Casey said, every change application that we've processed for ecology, metering requirement is on there. Every time ecology touches a water right, they put it on there. If it wasn't already on there previously, they will add it on to improve the data that's being collected, make sure that they know what's going on, make sure the water right holders know how much they're using so they're not going over their limits. And that was all I had. So there's contact information. Feel free to, you can email me or call me or catch me the rest of the day today if you have other questions about water rights in Whatcom County or anywhere else. So thank you very much for your time.
Last question for Andy. You'll be around.
Yep, I'll be around. Yeah.
So just to clarify, the infield, the in-stream will they apply to man-made leaks as well? Man-made.
Yeah, so an in-stream flow rule applies, or it's based on the surface water body, but any water that's flowing into it or tributary to it would also be applicable. So it would, if you have a well and that groundwater flows into the river that then has, the closed or the minimum in-stream flows, it would also get pulled into that. So they're trying to, anything upstream from that gauge.
And we wouldn't be able to mitigate that, or make it bigger or expand the leak?
You would have to be able to mitigate water for water, like the Foster decision says. So during the times when the flow is not met, you don't have to mitigate if the flows are being met, like for the surface water diversions, but you would have to mitigate the other times. So when the flow is not being met.
Okay, it's lunchtime. I'm sure you all want to get out of your seats. And Betsy's going to explain what's going on outside.
Pretty simple. We've got pizza and salad, and if anyone is looking for the free option, it's chicken with the salad. We try to bulk things up. So we're running today's event as towards zero waste. So we got compostable plates, all of your, everything you're going to use. So this big bin over